Well, hello. If you're watching this, you are involved in the course called Legal Negotiations for the summer of 2016 at Regent Law School. My name's Gus Nelson. I'll be guiding you through this process for the next several weeks, and we'll hope to make it useful and meaningful and practical as well as um, engaging. I'll do the best I can in that regard. A little bit of background very briefly. I am an attorney. I've been an attorney since 1988. I have practiced law in a variety of circumstances, and currently I am a divinity student at a seminary in Louisville, Kentucky. And I still work at a law office, though, and so consequently, I haven't really left the field at all. I've taught negotiations frequently since 2005. I've been reading about it since then. Have kept up with it, and so I can give you both practical and academic perspective on negotiations. And so hopefully I'll be able to do a little of both. Lastly, of course, and importantly, and really more important than anything else in my view, obviously, because I'm a divinity student, I'm a seminary student, the biblical application. How do you handle things biblically, and how do you know that you are engaged in negotiating in a Christ-like manner? So we'll talk about that throughout the course, and that'll be the salt that we dump on top, so to speak, of everything we do. So let's talk generally. Now, one other thing you need to know is that oftentimes with these lectures, I will not simply be going through the material in the book. I will be talking about things that strike me as I read the material. And by the way, I'm revamping the course, and so the lectures you're getting, these are brand new, and because I've switched books. And so I will just be kind of giving you some general overview of thoughts that pertain generally to the reading that you will have done each week. Now, with that in mind, let's dive in and let me give you some just general thoughts on negotiating and particularly legal negotiations. First, I want you to understand this key principle, okay? More than anything else in this course, well, more than as much as anything else in the course, negotiating is not in your DNA and it is not an art, okay? Negotiating is a skill just like any other skill. If you want to be a good auto mechanic, you better work on cars regularly. If you want to be a good golfer, you better go out and hit golf balls regularly. If you want to be a good artist, you better draw, paint, sculpt, whatever it is you're going to do regularly. If you want to be a good negotiator, you're going to have to negotiate regularly. That's a tough word to say. So part of what I want to convince you of is that you can do this and you can do it well. Now, maybe you won't be the greatest negotiator ever, but you can do it successfully. Okay, and it just takes some practice and some learning and some willingness to apply yourself. Legal negotiations, of course, is what we're talking about, and that means we're within a context. And the context is a legal matter, usually litigation, or often litigation, maybe a business transaction, but something in which lawyers play a prominent role. And so there'll be discussions throughout the course of negotiations in various contexts. And so I won't just simply have everything be a matter of a car accident lawsuit and who's negotiating what to get some money. In fact, that's rather routine and probably one of the most boring areas of negotiation. One of the more exciting and interesting areas, quite frankly, is negotiating criminal matters. And so you will be engaged in some of that at some level throughout the course, as well as other issues pertaining to divorce and business deals and so forth. And so I'll try to give you a broad spectrum of matters about which I will ask you to consider and think about negotiating. But we're in that context, which leads me to my next point. The rules of professional conduct will apply, whether you're the client or whether you are the lawyer or whether you are part of the legal team that's involved in a negotiation in a legal matter. The rules of professional conduct guide. Rule 1.2 in particular is a rule that we'll talk about, and that involves who gets to say what. And basically the rule has two essential components. A, the client always determines the outcome. That is, the client has the say on the objective of the negotiation as well as the result. The lawyer does have some leeway over B, the means to that end. And so the lawyer does have some control over how to do it, but the client has control over what to do. Okay, and that's very important, obviously. And again, you will be thinking about that, and we will talk about that throughout the course. And so this won't be the first time you'll hear it, and it won't be the last. You need to know your client's risk tolerance. It's very important because how the client wants to do things matters greatly depending on risk tolerance. That's a huge, important aspect of negotiating, whether you're the client or whether you're part of the legal team that's negotiating. If the client is extremely risk averse, then obviously that impacts how you negotiate. You can't take preposterous positions, for instance, if your client is very risk averse, because your client will be very unhappy, or if you're the client, you're going to be very unhappy with your lawyer, and B, you really can't back it up, and people will figure that out. That leads me to another problem. Biblically, from a Christian standpoint, can you bluff? Is bluffing acceptable? Can you? Because essentially when you bluff, you're lying. And so is that okay? Is it not okay? What do we do with that? If you're a Christian, how do you handle that? How, in your conscience, what do you do? Is it a matter of conscience? Or is it a matter of, I just can't do that? And I'll give you some tips along the way about things you can do and say in order to avoid putting yourself in a position of telling a blatant lie. And so we'll figure out ways that we can handle difficult matters and still maintain your integrity, if you will. If you are going through this process in order to possibly go to law school and then ultimately practice law, let me suggest this to you, that your integrity and the respect you gain from other attorneys matters a great deal more than whether you're a really smart guy or gal. Okay? And I can assure you that just from years of practice and getting to know lots of lawyers, and word gets around who you can trust and who you can't trust. And frankly, word gets around. I did litigation most of my life. In fact, still involved in it indirectly. And I can tell you right now that that matters a great deal. And so it's very important. Keep in mind that emotions will factor into negotiations no matter what. You can have two sophisticated business people, but they'll get irritated and angry and frustrated and depressed and all kinds of things. And the emotions will factor in. Why? You think it's a business deal. Who cares, right? It's all cut and dried. It's objective. We're just trying to get everybody squared away. And no. Why? Why do emotions matter? Because you're dealing with people. And people are emotional beings. Okay? Look around. Okay? Look around. Trust me, and then just look around and watch people and see if people aren't emotional beings. And so despite whether it's just a cut-dry business deal or not, emotions often will factor in, and you'll need to take account of those things. The negotiation is not legal advocacy. In other words, you're not arguing a case, at least not generally speaking. Nonetheless, there is a place for advocacy in negotiation, particularly legal negotiation. And I'm going to have to stop using words that have early in them so that I can speak clearly. Advocacy matters to a point. But the fact is that typically you're not arguing case law or statutes in a negotiation, at least not often. Now you may, and there may be points in time when you need to bring them up. I'll give you a brief, for instance. Recently I wrote a letter to a claims adjuster for my boss, and that letter laid out some specific legal realities that this claims examiner didn't seem to understand. And we needed to let her know that, hey, look, if you think you're going to offer us the offer you've made us in this matter, you need to think again, because here's some problems with your viewpoint, and the problems are legal problems that you have. If this gets pushed into litigation, you're going to have to deal with this, and you're going to have a very difficult problem dealing with it. And we laid out the statutory reasons why her position was incorrect, and it was necessary. So sometimes advocacy is required, but oftentimes it's not a matter of making the right legal argument when you're negotiating. I remember a magician back in the late 70s and early 80s. His name was Doug Henning, and he used to say, at least I remembered this. Now, I could be wrong, but I believe he used to say this: perception is reality and reality is perception. And he sort of had this sing-songy way of saying it. Reality is perception and perception is reality. And, you know, it was kind of this magician kind of thing, and then he would do some kind of crazy magic trick. Well, that's not exactly true, but there is a point to it, and that is that perception matters, even if it isn't reality. And I don't buy that. I think reality is objective. It nonetheless matters. Perception is important, and how the client perceives the matter, how the other side perceives the matter. If you are involved in a mediation or some sort of third-party involvement who is kind of monitoring your negotiations in some form or fashion, that their perception matters. So it's important to keep that in mind as we go throughout the course. How do people perceive this? And I'm particularly the involved parties who are negotiating. How do they perceive things? That doesn't mean that you let that become the be-all and end all, but it does mean that you take it into account. Last thing I'll talk about very quickly here in the sort of overview is this idea of competitive and cooperative negotiating strategies, or competitive and cooperative negotiating frameworks. Generally speaking, there's this idea, and this is throughout the literature in negotiating, that there are these two basic methodologies, if you will, strategies, frameworks of negotiating. Competitive negotiating tends to produce an adversarial relationship. Each side is attempting to undermine the other side's position in some way. Each sees the other party as an opponent. Generally speaking, each side is seeking the most advantageous resolution of the matter, and each side is really not terribly concerned about the relationship between the parties. That gives you a general taste of what competitive-oriented tactics or strategies or framework would look like. Cooperative negotiating, generally speaking, this is a general overview, seeks a fair and just solution to the problem. And you'll hear cooperative negotiators often talking about, well, let's try to get to a fair result. Let's try to get something fair for both sides, that kind of thing. A competitive negotiator would say, look, my client wants X, and that's what we're taking, and we've got to have it. And if we can't have it, then we'll see you in court. That would be the competitive version. Cooperative negotiators often seek goodwill, and so you will see this frequently. Well, I'll get to that in a second. Cooperative negotiators will often initiate concessions. They'll start the concessions going. Inevitably, in any negotiation, somebody concedes something, because if you don't, you never get a negotiation done, right? So somebody's got to start. Cooperative negotiations will often have somebody suggesting some objective criteria to measure the end result. Hey, let's look at what is the market. And, let's say you've got somebody who's trying to sell a business, and they say, well, look, the same business in Albuquerque went for $1.5 million. Albuquerque's a little bit of a different town, but it's a similar town than the one we're in. And so we can kind of generally look at that and say, that may be a reason to say that's an objective measure. Lastly, there's often a concern for the relationship among cooperative negotiations or negotiating parties. Here's an interesting reality. Among lawyers, cooperative negotiation is really the rule. And the fact is that lawyers, particularly lawyers who get to know each other, and lawyers tend to operate within a community of lawyers, generally speaking. Most of my professional life was involved in uh, personal injury cases from the defense side. In other words, I worked for a large insurance company and represented defendants in personal injury matters, people who were getting sued. And so I was often engaged with the same lawyers again and again and again. And so I got to know them and they got to know me, and we got to know how we each reacted to things. And so there was a concern on my part and theirs that our relationship be maintained even when we had clients who were one-shot clients. I mean, and particularly for me, I almost never saw my clients again. The personal injury guys might see their client more than once, but for me, it was almost inevitably no. I almost never saw my client a second time. Uh, so the relationship between me and the other attorney was more important to me than the relationship between me and the client, quite frankly, because I was never going to see that client again. That didn't mean I didn't advocate. It didn't mean I didn't work hard for them. And I'll give you one final war story as I wrap up here. I was involved in a mediation, and we'll talk about that towards the end of the course, in which I basically looked this plaintiff in the eye and just pointed at him and told him, look, he had a problem with alcohol. And I told him, listen, you take this to court and I'm going to spray your alcohol problem all over the courtroom again and again at every opportunity. Why? Why did I do that? Was I trying to mess up my relationship with these other attorneys by beating up on their client? No. They were a little surprised because that wasn't my normal MO to be that aggressive. But I was trying to make a point to this guy, look, I'm not afraid to do that, and I will. And you better be prepared to have your alcohol problem sprayed out in front of the public. And the case settled. Now, did it settle because of that? I don't know, but I think that had something to do with it. And there was a reason I did it, and it was legitimate. Don't get me wrong. I'm not suggesting I just said that because I was just trying to be ugly. I had legitimate reasons for telling him that I was going to try to get this evidence into court. And so I wasn't just saying things off the cuff just to be ugly. Did it hurt the relationship with the other attorney? Not really, because I explained to them what I was doing after the fact. They figured it out anyway. And so it did not hurt that relationship, even though normally I wouldn't engage in that kind of really raw, competitive sort of tactic. All right, well, there's some things to think about here as we start the course. I hope you'll enjoy the course. And go take the quiz when you're ready and work on the discussion board question.